Well, you just bought a new property. Congratulations. Now in California, there's several ways to take title. How are you going to do it? Let's talk about it. Hi everyone. For those who don't know me, my name is Cliff Hildreth. I'm a real estate broker and a lender here in Los Angeles. Now this video is going to be one of those wonky videos, but very necessary video if you're thinking of acquiring a property. Now a person is generally not considered a legal owner of a property until their name is added to the title. It's crucial for anyone who is buying a property to understand the various ways to hold title in California, because the California title vesting option they select will not only affect their ownership rights, but also the ways in which they are entitled to use the property. In California, there are 5 main ways to hold title. 1. Sole ownership. 2. Community property. 3. Community property with right of survivorship. 4. Joint tenants with right of survivorship. And 5. Tenants in common. So, let's go over the definitions of each one of the ways to hold title in California. Number 1, sole and separate ownership. If you're the sole and separate owner of real property, it means that you have an undivided interest in the property, i.e. there are no other owners. Now likewise, when a deed indicates that a certain piece of real estate is the sole and separate property of a given owner, it means that the intent of that owner of the property is to hold the property as their separate property. Now, however, if the property was acquired by one spouse during marriage, all or a portion of the property could be considered community property, i.e. property that is equally owned by both spouses, regardless of whether the title is acquired in the sole name of one spouse or the other, unless the other spouse signs a document waiving their ownership rights. Number 2, community property. California is known as a community property state. This means that the law presumptively considers any property that was acquired over the course of a marriage or domestic partnership as belonging equally to both partners, regardless of which partner acquired the property. In contrast, property acquired via gift or inheritance or property acquired prior to the marriage is not considered community property. Now, because community property laws only entitle each spouse or domestic partner to a 50% interest in the marital property, they cannot dispose of more than their 50% share of the property through their estate planning documents. Similarly, if a couple gets divorced, each spouse will only be entitled to 50% of the property, subject to some exceptions. Many couples who get divorced decide to sell the property and divide the proceeds equally. The only time community property laws may not apply is if the spouse or domestic partners had previously entered into a marital agreement, like a prenuptial or postnuptial agreement, in which they waived their community property rights. Number 3, community property with right of survivorship. Now, despite sounding similar, community property and community property with right of survivorship in California have very different implications. So, what is the right of survivorship in California? It's the right of survivorship automatic. If title of the property is held as community property with the right of survivorship, it simply means that the surviving spouse or domestic partner automatically assumes full ownership of the property upon the death of the other spouse. Now, conversely, if title is held just as community property, as I discussed previously, then the deceased spouse has the right to dispose of half the property through their will or their trust. Number 4, joint tenancy with right of survivorship. Joint tenancy is a form of title in which 2 or more persons share equal ownership of the property, in addition to being equally responsible for any obligations like debts or repairs that arise as a result of it. Joint tenancy with the right of survivorship in California title vesting option that can be used by any 2 or more people regardless of whether they are in a marriage or a domestic partnership. A key component of joint tenancy agreements is the right of survivorship. In other words, when one joint tenant dies, the other joint tenant or tenants automatically gain ownership and usage rights of the deceased tenant's share of the property. Now, it's not possible to have joint tenancy agreement without the right of survivorship being implied. Number 5, tenancy in common. Now, tenancy in common is another viable option for 2 or more owners who wish to jointly own a property. When a property has tenants in common, it simply means that ownership is shared and that each owner has a distinct and transferable interest in the property. If multiple parties are jointly purchasing a property but cannot make equal contributions, tenancy in common is a good way for them to hold title, as equal contributions are not required with this California title vesting option. For instance, if a tenant in common can only afford to pay 20% of the purchase price, they could secure a proportional 20% interest in the property, with the remaining 80% interest going to the other tenant in common. Unless they have entered into a legal contract that forbids them to terminate their interest in the property, tenants in common also have the legal right to sell their share of a property. The key feature of tenancy in common is that owners do not have a right of survivorship, i.e., there is no such thing as tenants in common with right of survivorship. In other words, if a tenant in common dies, their portion of the property will either go to their heirs if they don't have an estate plan, or be disposed of through their will or trust. Comparing California's title vesting options. Now, based on the information, what is the ideal way to hold title in California? How do you want to hold title if you're single? How do you want to hold title if you're jointly purchasing a property with others? If the property in question belongs to a trust? It is important to learn the answers to these questions before vesting title, because to choose the California title vesting option that's right for you, you will need to consider a variety of factors, including your marital status and ownership interest, the type of property in question, of course, tax implications, and your estate planning goals, among other things. Because the specifics of your situation determine which California title vesting option is best for you, you should really consult with a lawyer who can present you with the advantages and disadvantages of each California title vesting option before you make a decision on how to take title. So, now that I've covered the basics, I have to give my little disclaimer. I'm not an accountant or an attorney, and I'm not trained or qualified to tell you which type of title is best for your particular situation. Because the specifics of your situation determine which California title option is best, speak to a lawyer or an accountant trained in real estate law who can present you with the advantages and disadvantages of each title option prior to your making the decision. So I hope these tips helped. Also, if you like my videos, please don't hesitate to subscribe to my YouTube channel by clicking on the subscribe button below. And if you click on the little bell next to the button, you'll receive a notification of any new videos. A like would be appreciated as well. And of course, as always, please don't hesitate to call, text, or email me the information below if you have any questions about this or any other real estate or lending related subject. Even if you're not ready to buy or sell right now, I'm always happy to help in any way that I can. So, have a great day, and remember, together we can make it happen.